Hey everybody, how you doing? Hopefully well. Today I'm going to be reading a court case, Century Electric First Commissioner. That's the Commissioner of the IRS. This is a tax dispute. This is something related to tax, so accountants, and then also obviously law, so accountants and lawyers take interest in this, but the goal of this video is for you to not take interest in this and rather just to fall asleep, because that's what will happen to most people if they read something like this. It's going to be very boring, but I'm going to have to suffer through it. You don't, you just have to listen. I have this candle here, salted coconut and mahogany from Wicked Wood, Wood and Wick. I had to make a joke there, but I decided against it. Okay. I might make a video with these. Cap sounds really nice. Okay, let's do this without burning myself. Hopefully that sounds nice and relaxing. Alright, let's begin. Century Electric First Commissioner, United States Court of Appeals, 8th Circuit. Just out of curiosity, I'm going to see where the 8th Circuit is. Oh, it's quite a few. Arkansas, Iowa, Minnesota, Missouri, Nebraska, North Dakota, South Dakota. So I guess kind of like the Midwest, sort of. It's kind of a broad area. Yeah, that's the Midwest. And it is in St. Louis. So just a fun fact there. Okay, now let's really begin. Century Electric First Commissioner, 8th Circuit. October 31st, 1951 is when this decision was released. So just some background information here. I'm going to go through this rather quickly. A transaction where an electric company conveyed its foundry building, used in its manufactured business, and land on which it's situated to college for a specified sum and received lease for such property from college was not for income tax purposes a sale of foundry property, but exchange of property held for productive use in trade or business for property of like kind to be held for such use, so that company was not entitled to deduction of loss in transaction. A transaction wherein neither gain nor loss is readily measured in terms of money and no change is affected in taxpayer's economic situation, though he may have realized gain or loss in theory, is an exchange, not a sale, for income tax purposes, so as to preclude loss deduction. In computation of gain or loss on taxpayer's transferred property held for productive use in trade or business for property of like kind to be held for such use, market value of properties does not enter into equation. A transaction may not be separated into its component parts for tax purposes, but tax consequences depend on what was actually intended and accomplished rather than on separate steps taken to reach desired end. The Treasury regulation interpreting words like kind in provision of Internal Revenue Act that no gain or loss shall be recognized on exchange of property held for productive use in trade or business solely for property of like kind to be held for such use, as including lease within 30 years or more run in several as including lease with 30 years or more to run in real estate, has acquired force of law as a result of being enforced for many years in surviving successive reenactments of Internal Revenue Acts. And lastly, an electric company, which was denied loss deduction, claimed in its income tax return on transfer of its foundry property to college for cash and leased property to company, was entitled to deduct amount of claimed loss as depreciation on leasehold over term of lease, not over remaining life of improvements on foundry. Okay, wow. So a lot to unpack there. Am I going to unpack it? No, I'm just going to keep going. But wow. So opinion by Judge Riddick. Opinion: before Sanborn, Johnson, and Riddick, circuit judges. So here we're getting the opinion, and I might go through and highlight some things. Okay. The petitioner, Century Electric Company, is a corporation engaged principally in the manufacture and sale of electric motors and generators in St. Louis, Missouri. So they sell electric motors and generators in St. Louis. It is not a dealer in real estate. As of December 1st, 1943, petitioner transferred a foundry building owned and used by it in its manufacturing business and the land on which the foundry is situated to William Jewell College, and claimed a deductible loss on the transaction in its tax return for the calendar year 1943. The Commissioner of Internal Revenue denied the loss. The Commissioner was affirmed by the tax court, and this petition for review followed. So key things there. Century Electric, not a dealer in real estate. And they transferred a foundry building owned and used. So a transfer of building for manufacturing, used for manufacturing business, to a college, and claimed a deductible loss. The Commissioner denied it, and the tax court affirmed the Commissioner's decision. So that means the tax court said, we agree with the Commissioner. Note: the next paragraph explicitly states that the facts are determined at the trial court level. This means that you may have to read the trial court opinion in order to really understand the facts that are related to the litigation. The Eighth Circuit does provide the cite to the trial court's opinion. We're not doing that. The opinion of the tax court and its findings of fact stated in great detail are reported in 15 TC 581. Petitioner accepts the tax court's findings of fact as correct. The next few paragraphs, that's important. The petitioner accepts the tax court's findings of fact, keyword fact, as correct. So obviously the petitioner, being Century Electric, they're appealing, so they don't agree with the ruling, but they say the facts they used to make their ruling is correct. So no details about them were untrue. They just applied the law in the wrong way, I guess. The next few paragraphs provide a highly summarized statement of the facts. Okay. Here we go. This is going to be a lot. Going to need this. Since its organization in 1901, petitioner has been continuously successful in business. Okay, so what? In its income tax return for the year 1943, it reported gross sales of $17 million and gross profits from sales of about $6 million. On December 31st, 1942, petitioner owned land, buildings, and improvements of the total depreciated cost of about $2 million. On December 31st, 1943, its actual cash on hand amounted to $200,000. During the year 1943, it distributed cash dividends of $200,000 and made a contribution to Washington University of $42,500. It also held tax anticipation notes and Series G bonds totaling $2 million, readily convertible into cash and sufficient to liquidate its outstanding 1943 tax liability and its two outstanding 90-day banknotes due January 20th, 1944. Okay, so I don't know why all that is in there, but kind of here it's saying the petitioner said this is all true. So far, the petitioner agrees. Petitioner has always operated its business in large part on borrowed capital. In 1943, it had opened lines of credit with the Chase National Bank of New York of $300,000, with the Boatman's National Bank of St. Louis of the same amount, and with the Mercantile Commerce Bank and Trust Company of $400,000. At the end of 1943, its outstanding loans from the Mercantile Bank amounted to $600,000 approved by the authorized officers of the bank. Petitioner has always been able to liquidate its outstanding 90-day bank loans as they become due either by payment or renewal. Okay. That's whatever. Here we go. This is where it gets important. The assessed value of the petitioner's foundry building and land upon which it located for 1943 was $780,000. There was evidence that in St. Louis real property is assessed at its actual value. There was also evidence introduced by petitioner before the tax court that made the market value for unconditional sale of the foundry building, land, and a something was not in excess of $250,000. Okay. So let's go into this. Assessed value of their foundry building and land. Evidence that the market value was not in excess of $200,000. Okay. As of December 1st, 1943, the adjusted cost basis for the foundry building, land, and what is this? Appurtenances. We're going to go to Google again. An accessory or other item associated with a particular activity or style of living. Example being driveway, ceiling fan, fences, fixtures. Okay. Makes sense. Okay, so the adjusted cost basis for the foundry building, land, and appurtenances transferred to William Jewell College right away. Adjusted basis transferred to the college, $500,000. The building was a specially designed foundry situated in a highly desirable industrial location. It is undisputed in the evidence that the foundry property is necessary to the operation of the petitioner's profitable business, and that the petitioner never at any time considered a sale of the foundry property on terms which would deprive petitioner of its use in its business. Okay. Petitioner's explanation of the transaction with the William Jewell College is that in the spring of 1943, a vice president of the Mercantile Bank, where petitioner deposited its money and transacted the most of its banking business, suggested to the petitioner the advisability of selling some of its real estate holdings for the purpose of improving the ratio of its current assets to current liabilities by the receipt of cash on the sale and the possible realization of a loss deductible for tax purposes. Petitioner's operating business was to be protected by an immediate long-term lease of the real property sold. Important. I need to move this for a second. I need to dive into this. I'm kind of sitting really awkwardly. Okay, this is what I was wondering. Petitioner's explanation of the transaction, because it was weird. It was strange. I didn't understand why petitioner made this transaction. So I'm going to give this a star. So, vice president of bank suggested to petitioner selling real estate holdings, improving ratio of its current assets to current liabilities, sell your real estate, get cash, assets, deduction. Makes sense, okay. I get it, I suppose. Petitioner's board of directors rejected this proposition as unsound, but in July 1943, when a vice president of the Mercantile Bank suggested to petitioner's treasurer that it would be a good idea for petitioner to pay off all its bank loans merely to show that it was able to do so, petitioner interpreted this advice as a call of its bank loans. Acting on this interpretation, petitioner borrowed from the First National Bank in St. Louis on the security of tax anticipation notes held by it, funds with which it was discharged all its bank loans. Immediately thereafter, it re-established its lines of bank credit and began consideration of the sale of the foundry property and contemporaneous lease from the purchaser. Running out of water here. I don't know, that was weird. On September 2nd, 1943, petitioner's board of directors adopted a resolution that the executive committee of the board study the situation and present, if possible, a plan covering the sale and rental back by Century Electric Company of the foundry property. Sorry, I need to go slower. Petitioner's board of directors rejected this proposition as unsound. No, I was here. On September 2nd, 1943, petitioner's board of directors adopted a resolution that the executive committee of the board study the situation and present, if possible, a plan covering the sale and rental back by Century Electric Company of the foundry property. The decision to enter into the transaction described was communicated to the Mercantile Bank, but petitioner never publicly offered or advertised its foundry property for sale. The tax court found that petitioner was concerned with getting a friendly landlord to lease the property back to it, as there was never any intention on the part of petitioner to discontinue its foundry operations. Several offers to purchase the foundry property at pricing ranging from $110,000 to $450,000 were received or rejected by the petitioner. Okay. Petitioner was concerned with getting a friendly landlord to lease the property back to it. Never any intention petitioner to discontinue its foundry. At a special meeting of the board of directors of petitioner on December 9, 1943, the president of a petitioner reported that the officers of petitioner had entered into negotiations for the sale of the foundry property to William Jewell College for the price of $150,000, with the agreement of said college that in addition thereto, and said trustees of William Jewell College further have agreed to execute a lease of the property so purchased of Century Electric Company for the same time and on substantially the same terms and conditions which were authorized to be accepted by the special meeting of shareholders of this corporation held on the 24th day of November 1943. So, Century Electric controls the lease terms. So you guys buy the property and you lease it to us, but we control the lease terms. The stockholders at the November meeting had authorized the sale of the foundry property at not less than $150,000 cash, conditioned upon the purchaser executing its lease of the property sold for a term of not less than 25 years and not more than 95 years. The foundry property cannot be sold less than $150,000 as long as the purchaser executes the lease. No less than 25, no more than 95. Interesting. The board by resolution approved the proposed transaction with the William Jewell College, but on condition that this corporation will acquire from trustees of William Jewell College and Missouri Corporation an indenture of lease for a term not of less than 25 years and not for more than 95 years. The resolution set out in detail the terms of the lease from the college to petitioner, approved the form of the... Sorry, let me move this back. I don't know if you can see. We're right here. Approved the form of the deed from the petitioner to the college, authorized the president and secretary of petitioner to execute the lease after its execution by the trustees of the college, and directed that the president and secretary of this corporation be authorized to deliver said warranty deed to said purchaser upon receiving from said purchaser $150,000 cash, and upon receiving from said purchaser duplicate executed indenture lease on the forms exhibited to this board. The resolution provided that the deed and lease should be dated December 1st, 1943, and effective as of that date. The deed and the lease were executed and delivered as provided by the resolution of Petitioner's Board of Directors. Neither instrument referred to the other. The deed was in form a general warranty deed, reciting only considerations of $150,000 in cash. The lease recited, among others, respective covenants of parties and terms, termination by the lessor, leasing, and as the rents reserved, blah blah blah. We really like to get into the law part of this. I'm sick of the facts. I just repositioned myself. Hopefully everything's fine. That wasn't too loud, and hopefully you can still hear me okay. Okay. Here we go. Right here. As of December 31st, 1942, the ratio of petitioner's current assets to its current liabilities was 1.74. The $150,000 in cash received by petitioner on the transaction increased the ratio of current assets to current liabilities from 1.74 to 1.8. The loss deduction which petitioner claimed on the transaction and its consequent tax savings would, if allowed, have increased the ratio approximately twice as much as the receipt of the $150,000. Okay. So the $150,000 they received increased it from this. The loss deduction would, if allowed, increase the ratio twice as much. So instead it could have gone from 1.8 to 3.6. So that's a big difference. That's really important. Note, the opinion begins here. In thinking about how to write a tax memorandum, notice that the relevant statute is identified very quickly. That statute might be presented in the opinion or in a footnote. Okay. This is just important to me. It's not important to the case. It's important for me. I'm learning. This is for a class. It's for a tax research class. So I'm trying to learn how to understand all this. 1, 2, 3. The questions presented are: whether the transaction stated was for tax purposes a sale of the foundry property within the meaning of Section 112 of the Internal Revenue Code, Section 112 of the Internal Revenue Code, 26 USA, Section 112, on which petitioner realized in 1943 a deductible loss of $400,000 determined under Section 111 of the Code, the adjusted basis of the foundry property of $500,000 less $450,000, as petitioner contends, or as the tax court held, an exchange of property held for productive use in a trade or business for property of a like kind to be held for productive use in trade or business, in which no gain or loss is recognized under Sections 112B1 and 112E, and Regulation 111, Section 29.112B1-1. Jesus. Let's get back into that. Let's do that again. So the question presented: what's the court trying to decide? Whether the transaction stated was for tax purposes a sale of the foundry property. So was it a sale of the foundry property within the meaning of Section 112? On which petitioner realized a deductible loss determined under section 111 of the code. So that's saying this number here is the 500,000 adjusted basis, 5 minus 250,000 gain or amount realized. And that's the loss. That's basic accounting right there. I'm just laying it out for me to get a full understanding because this is complicated stuff. As petitioner contends. So that's what petitioner says. Or, as the tax court held, an exchange of property. So they say, petitioner says sale, tax court says exchange. Tax court held an exchange of property held for productive use in trade or business for property of a like kind to be held under productive use in trade or business in which no gain or loss is recognized. No gain or loss is recognized under sections 112B1 and 112E and regulation and section whatever. Okay, up here. This is just saying, come back down here for a second just to talk about this. They're saying the petitioner said, me selling my warehouse was a sale, which is different from what the tax court is saying, which is what is it was an exchange. And I'm sure they'll talk about the difference here, but to my understanding, the difference is a sale is when you say they sell the factory for money, and there's some type of loss or gain, like there was here, which is what the petitioner is saying. Then it's a sale. Whereas an exchange is you exchange a warehouse for something else. So I guess in this case they could be saying that this whole lease term is just something else, and then whatever the difference is in the fair market value of those two items, so like whatever the technical loss or gain is, you make up for it with money. So there's still money involved, but in a sale, that's all that's involved, versus an exchange, there's other factors. That's how I understand it. We'll see what they say. I'm sure they'll talk about it. Let me sit up again. This is pretty uncomfortable. Okay, only a couple more pages to go. Number 2. Whether if the claim loss deduction is denied, its amount is deductible as depreciation. So this is another question. Whether if the claim loss deduction is denied, its amount is deductible as depreciation over the 95-year term of the lease as the tax court held, or over the remaining life of the improvements on the foundry as the petitioner contends. Big note here. In the paragraph that immediately follows, the Eighth Circuit explicitly rejects a literalism approach that involves the common everyday meaning of words, i.e. think dictionary, and adopts a congressional intent approach to interpreting the statute. It is the propositions to be proven or conditions that must be interpreted. Specifically, the Eighth Circuit felt like the meaning of exchange and like kind must be determined. In other words, the focus is on defining the conditions. Recall that the definitions of a requirement, condition, qualification, prerequisite, factor, or proposition to be proven should clearly indicate what facts are relevant for proving that condition. So here's a note from the writer. The writer of this, technically a textbook form, but it's a textbook, who also used to be a professor of mine, has left this note, and this seems very important. So the Eighth Circuit rejects a literalism approach. So instead of going into the tax code and saying that's what this word means, that's what this word means, they're going to interpret the statute. So it's the proposition to be proven that must be interpreted. Propositions to be proven that must be interpreted. Oops. Specifically, the Eighth Circuit felt like the meaning of exchange and like kind must be determined. Meaning of exchange and like kind must be determined. Focus is on defining the conditions. Recall that the definition of a requirement condition, the requirement of a condition should clearly indicate what facts. The definition of a condition should clearly indicate what facts are relevant for proving that condition. Okay. Let's see what they say. On the first question, the tax court reached the right result. Note that the next sentence is going to mention both literal interpretation and congressional intent interpretation. The answer to the question is not to be found by a resort to the dictionary for the meaning of the words sales and exchanges in other contexts, but in the purpose and policy of the Revenue Act as expressed in Section 112. And then they have a bunch of cited court cases here that they use to make this decision. In the next few sentences, the Eighth Circuit is going to define the exchange condition, what facts are relevant for determining if that condition is satisfied. In this section, Congress was not defining the words sales and exchanges. It was concerned with the administrative problem involved in the computation of gain or loss in transactions of the character with which the section deals. I'm just trying to understand. So Congress was not defining the word sales and exchanges. Concerned the administrative problem involved in the computation of gain or loss in transactions. Let's just keep going. Indicate the controlling policy and purpose of the section. That is, the non-recognition of gain or loss in transactions where neither is readily measured in terms of money, where in theory the taxpayer may have realized gain or loss. The previous 11 words is a reference to the concept of legal severance that is associated with the definition of the word income as used in IRC Section 61. Not worried about that. That was not important. This is all not written by the court, by the way. We're away from that. I think we will have more of that at the end. Or you know what, I think this is the court, but these notes aren't. Sorry, my mistake. Okay, let's go back. Where in theory the taxpayer have realized gain or loss, but where in fact his economic situation is the same after it was before the transaction. Okay? That's important. Taxpayer may have realized gain or loss, but economic situation is the same after as it was before. I have some citations here, and then right here, for tax purposes, the question is whether the transaction falls within the category just defined. If it does, it is for tax purposes an exchange and not a sale. So, if your position is the same as before, it's an exchange. I'm going to write that down. Exchange, position, same, after, sale. Even though it's not a sale, it's an exchange. So I'll just write position same after as before. So much is indicated by subsection 112b1 with regard to the exchange of securities of readily ascertainable market value measured in terms of money. Gain or loss on exchanges of the expected securities is recognized. Under subsection 112e, no loss is recognized on an exchange of property held for productive use in trade or business for like property to be held for the same use, although other property or money is also received by the taxpayer. Compare this subsection with subsection 112c1, where in the same circumstances gain is recognized, but only to the extent of the other property or money received in the transaction. The compensation clearly indicates that in the computation of gain or loss on a transfer of property held for productive use used in trade or business for property of a like kind to be held for the same use, the market value of the properties of like kind involved in the transfer does not enter into the equation. Let's try and break that down. So, subsection 112e, no loss on an exchange of no loss recognized on exchange of property held for productive use in trade or business for like property held for the same use, although other property or money is also received. So, if you've never taken any type of law or tax class, this is definitely confusing, but this is how the Internal Revenue Code works. In the obviously, this is the United States. You have the Internal Revenue Code. They have sections. One of them is subsection 112e, and this is what it says. If you have an exchange of property held for productive use in trade or business, so basically property you use in your company or your business to do something profitable, held for productive use in trade or business for like property, so you exchange a productive property use in trade or business for another productive property use in trade or business. So that's like property, the same thing basically. To be held for the same use, so you're not going to change it to something else. You're going to keep it as productive use in trade or business. You're not going to turn it into your home, is basically what it's saying. Although other property or money is also received. So it's not a one-to-one thing. It's, like I said, an exchange. It's a thing for a thing and some money. Compare the subsection with subsection 112c1. Same circumstances, gain is recognized, but only to the extent the other property or money received in the transaction. The comparison clearly indicates that in the computation of gain or loss on a transfer of property held for productive use in trade or business for property of a like kind to be held for the same use, the market value of the properties of like kind involved in the transfer does not enter into the equation. So those are kind of conflicting there, it sounds like. The paragraph that immediately follows states and applies the step transaction doctrine. You can ask in class for elaboration if you're interested. We can't do that. The transaction here involved may not be separated into its component parts for tax purposes. Tax consequences must depend on what actually was intended and accomplished rather than on separate steps taken to reach the desired end. The end of the transaction between the petitioner and the college was that intended by the petitioner at its beginning, namely the transfer of the fee and the factory property for the 95-year lease on the same property and $150,000. I have a big note here from the professor. Let's read it, why not? We're at about 40 minutes. Should take no more than an hour. Note, in the paragraph that immediately follows, the Eighth Circuit applies the concept that it associates with exchange condition to the Century Electric facts. What is that concept? What is that concept? Can you see the facts being used to prove the concept? Pay attention to the fact that the paragraph also states and applies the like-kind condition. Understand that the non-recognition rule states stated in the statute only comes into play if the facts prove not only the exchange condition but also the like-kind condition. Since the Eighth Circuit concluded that the exchange condition was proven, it then had to make a determination regarding the like-kind condition. Finally, the last sentence in the paragraph states the reenactment principle. What is the reenactment principle? Well, we're not going to worry about that. But basically what he's saying, when you're trying to prove something in tax law, the courts, they go and they say, there's this section in the code here that says if you have this, and this is what you do. So they're trying to say, we have a situation, it has this, and this, so this is what we're going to do. And for all those this, every single one of them needs to be true, like 100% true. There's not a lot of room for judgment. I mean, there is, but it can get dicey. I don't know. You want it to be pretty spot on. So, in these conditions we had here, I talked about earlier, exchange of property, health, productive use for like property. My professor is saying, well, they've already said, okay, it's an exchange. It's obviously property held for productive use in trade or business. It's going to be held for the same use, money's received, but is it like property? Is it like property? That's what they're trying to decide. Okay, a little note here. Note that this application simply takes the exchange condition as it has been defined by the Eighth Circuit and deductively applies it to the facts specified in the opinion. This is nothing more than a straightforward application of the tax decision process, just like what was done throughout Tax 5025, 5027. Those are just classes that I took. The other way to apply is to compare the facts of Century Electric to the facts of other interpretive authority as required under the concept of stare decisis. If the facts are very similar, then the holding of the interpretive authority becomes the conclusion for Century Electric. If the facts of the interpretive authority are deemed to be different than the holdings of the interpretive authority, is not relevant to Century Electric's situation. Remember, at the end of the day, you are going to be asked to do this, so try to move on the learning curve. To understand these two fundamentally different approaches to application and the potential talent, you might deal both in order to strengthen your arguments. I'm gonna have to go back and read that myself. That's for me. Don't pay attention to that. It is undisputed that the foundry property before the transaction was held by petitioner for its productive use in petitioner's business. After the transaction, the same property was held by the petitioner for the same use in the same business. So, held for the same use. Yep. Both before and after the transaction, the property was necessary to the continued operation of petitioner's business. The only change wrought by the transaction was in the estate or interest of the petitioner in the foundry property. Now the like-kind condition is dealt with. Note that the Eighth Circuit simply identifies a condition, defines a condition, and applies a condition without any discussion of the condition. In Regulations 111, Section 29.112b1-1, the Treasury has interpreted the words like kind as used in subsection 112b1. Under the Treasury interpretation, a lease for 30 years or more to run in real estate are properties of like kind. With the controlling purpose of the applicable section of Revenue Code in mind, we cannot say that the words like kind are so definite and certain that interpretation is neither required nor permitted. The next sentence is the reenactment concept. If you're interested, right here, the regulation enforced for many years has survived successive reenactments of the Internal Revenue Acts and has thus acquired the force of law. And some citations. Why is it necessary for the court to write the last paragraph? I don't know. On the second question, the tax court held that the petitioner was not entitled to depreciation on the improvements of the foundry property over the useful life after it. We weren't really worried about the depreciation part. We were more interested in the first question. Let's just read this anyway. the second question, the tax court held that the petitioner was not entitled to depreciation on the improvements on the foundry property over their useful life after December 1st, 1943. The answer to this question depends upon whether, as a result of the transaction, under the consideration, the petitioner had an identifiable capital investment in the improvements on the land covered by the lease. Petitioner contends that the amount of its claim loss, about $400,000, should be apportioned between the land and improvements in proportion to their respective cost bases as of November 30th, 1943. This would result in an allocation of about $300,000 of petitioner's investment to leasehold to the improvements and $100,000 to the land. The difficulty with the petitioner's position is that it involves assumptions and inferences which find no support in the record. What the petitioner has done is to exchange the foundry property having an adjusted basis of $500,000 on December 1st, 1943 for a leasehold and $150,000 in cash. Its capital investment is in the leasehold and not its constituent properties. Accordingly, we agree with the tax court that petitioner is entitled to depreciation on the leasehold. The basis for depreciation on the leasehold, December 1st, 1943, is therefore $400,000. That a decision of the tax court is affirmed. Okay, wow. I tried my best to make notes and follow along, but I'm pretty new to this, so it's hard for me to kind of break this down. Let's do the next one. No, I'm kidding. So, if I go back into my little book here, not as far back as I thought, we have, and you can see I already marked this up, the brief of this case, which is basically like a summary. So I'm going to read through this, and hopefully it'll make better understanding of what we just read. So, of course, Century Electric Co. v. Commissioner, 1951. So the facts. Century Electric sold its St. Louis, Missouri manufacturing facilities for $150,000 cash, its basis in the facilities being $500,000. The purchaser immediately leased the property back to Century Electric for 95 years. The primary consideration was finding a friendly landlord. Therefore, the property would not be sold until the purchaser agreed to a long-term lease. And the property was never publicly offered for sale. The assessed value of the property for property tax purposes was $200,000, which approximately estimated fair market value. In no event was fair market value greater than $250,000. Several offers of $100,000 and $150,000 were received. No information was given concerning the fair rental value, and the property was sold for $150,000 to a non-profit, tax-exempt institution, i.e. a college. Issues. Is the transaction described in the facts a sale on which the taxpayer recognizes a deductible loss or an exchange under IRC Section 1031? Is the leasehold interest received like kind relative to the fee simple interest given up? Is the loss which is not recognized because Section IRC 1031C equal to the basis of the leasehold which can be amortized over the term of the lease? Reasoning. In Century Electric, the court approached the sale versus exchange issue by noting that the answer is not to be found by a resort to the dictionary for the meaning of the words sale and exchange, but in the purpose and policy of the Revenue Act as described in Section IRC Section 112, now IRC Section 1031. Okay, that's something I was confused on. I kept saying, what's Section 112? It's Section 1031, which is what we kept reading about property for like kind, for trade or business, that stuff. That's Section 1031. So they refer to that instead of a dictionary. Obviously, that's what you're supposed to do. Thus, in the sale versus exchange controversy, the proposition to be proven in the Eighth Circuit's view is whether or not there's been a substantive change in the taxpayer's economic position. In comparing that position of the century before and after the transaction, the court observed that before the transaction, the property was held for Century for productive use in Century's business for the remainder of its useful economic life. After the transaction, the same property was held by Century for the same use and the same business for the remainder of its useful economic life. Therefore, it was concluded that the transaction was an exchange because the taxpayer's economic situation was unchanged. Okay. Alright. So this is all starting to make a lot more sense. So, they're saying, by definition, in this code section, not definition because they're saying no dictionaries, but they're just saying what an exchange is when you exchange something and your position before and your position after economically are at the same level. So you didn't really have a gain or a loss. And didn't we write that down? Didn't we even write that down in the... Yes, position. Same after as before. And they're saying Century held the property for productive use, and after they still held it for productive use. It was still theirs. They sold it, but they were the ones leasing it. So it's not like they really sold it. Okay. Having concluded that the transaction was an exchange, the Eighth Circuit addressed the issue of whether the lease is like-kind relative to the foundry, referring to a regulation stating that a lease for real property with 30 years or more is to run is like-kind relative to a real property and nothing, and noting the common law principle of reenactment as well as the argument of regulations being enforced for many years to support the administrative interpretation, the court concluded that the lease was like-kind. I guess they're basically saying the lease is like-kind because the lease is for the building that you just sold. Like, how is that not like-kind, right? Finally, the court determined that the $380,000 loss that was unrecognized because of IRC Section 1031 would be the basis of the leasehold and that it should be amortized over the term of the lease. That's kind of whatever. Holding, the Eighth Circuit held that the transaction involved was an exchange, that the leasehold interest received was like-kind relative to the manufacturing facilities given up, and that the unrecognized loss should be considered to be the cost of the leasehold, which is to be, okay, that's what we just read. Alright. And this is the law that comes from it. So, my note here, because of this ruling in 1951, this is kind of the law that we apply now. If somebody was to go back, how they do courts, and they had a case similar to this one, and they found this, when they made their argument, say a lawyer made their argument, they would cite this case as why. And assuming all the facts are the same, the court pretty much has to agree with what this court says, unless there is some fact that isn't the same. When you dive deep into it, it's really not the same, or it could be this decision somehow is wrong. When they do further research, they find facts or legislature or statutes that say this is not true, or sometimes times change and laws change. This is back in 1951, so who really knows what it is now? But because of this holding, the law narrowly stated, if a taxpayer sells manufacturing facilities at a loss to the nonprofit tax-exempt college, if the college immediately leases the property back to the taxpayer, if the primary consideration is finding a friendly landlord so the property will not be sold unless the purchaser agrees to a long-term lease, if the property is never publicly offered for sale and its fair market uncertain, and if no evidence is provided with respect to its fair rental value. So all the facts that we've been talking about, the transaction is an exchange under IRC Section 1031. I highly doubt anybody listened to pretty much any of this, but in the rare case anybody did, that's really awesome, and let me know if you understood any of this. But I don't know who in their right mind would want to watch this, so hopefully you didn't. Hopefully nobody's listening. But yeah, that's Century Electric First Commissioner.